Have a seat.
I'm not.
Have a seat.
Your Honor, I haven't had
Have a seat. Did you understand what I just said?
Can we agree to disagree on the legalese?
We are not going to agree to anything. This is not your game to play here.
So you're saying that I have to say the words, I understand?
Sir, I'm not saying that you have to say anything. You can play games with me all day. I got all day. I got all day. Have a seat. Do not interrupt me.
I can object to that.
Do not interrupt. Do not. One more time. You're going.
All right, everyone. Today we are looking at one of the most disruptive and misguided sovereign citizens to appear before Judge Simpson. From the start, he tests the patience of the court and steadily pushes the limits of what any judge is willing to tolerate. The exchange quickly builds tension, and it feels like we are watching someone move closer and closer to a contempt finding in real time. Every interruption and misplaced argument adds fuel to a situation that is already on edge for those who follow these courtroom moments closely. This hearing delivers intense back and forth and a clear lesson in how not to address the bench that as you watch. Consider how you would assess his judgment and decision making, because the unfolding events speak volumes on their own. Now let us step into the proceedings and see how Judge Simpson handles yet another challenge to courtroom order.
Good afternoon, Your Honor.
State your name.
My name is Daniel Magoo, for the record, Your Honor.
You're going to represent yourself in this matter, sir?
Yes, sir.
I do have to advise you that in this case, you are charged with the offense of assaulting, resisting, or obstructing a police officer. That is a high court misdemeanor felony, punishable by up to 2 years and/or $2,000 fine plus court costs. You understand that?
I understand your charge.
You understand also that there is great peril in one representing themselves. You understand that, sir?
I'm not afraid, Your Honor.
Did you understand what I just said? That there is great peril in representing oneself.
I comprehend what you're saying, Your Honor.
Tell you what. Either you're going to answer my questions and you're going to answer them properly, or we're going to have a long time and I'm not going to have these people wait. So while you decide how you're going to handle this, I'm going to have you have a seat. I'm going to pass your case. You will come back up and you will learn how to operate within this court. Plain and simple. Have a seat. Have a seat. And you might want to wipe that smirk off your face while you're doing it. State your name.
Good afternoon, Your Honor. My name is Daniel Magoo.
I have stated the admonishments that I was giving to the defendant representing himself. I apprised him of the maximum penalties and the charges. Apprised him, and sir, I'll ask you the question again. You understand that there can be great peril in representing yourself?
I fully recognize and acknowledge the seriousness of the charges, with allegations of...
Not my question. You understand that there can be serious peril in representing yourself.
I recognize what you're saying. I'm fully prepared to proceed with this matter.
Will you just do me a favor and answer my question? Do you understand that there is great peril in representing oneself?
I recognize that.
Okay, let's stop there.
Yeah.
You recognize.
Recognize.
Do you understand that that in any of the proceedings that the court would hold you to the same standards as if you were a practicing attorney, will give no leeway one way or the other, will show no favoritism or no bias because you are representing yourself? You understand that, sir?
I recognize what you're saying, Ron.
You know what? I don't know why you just won't understand. I'm asking you, and I need a direct answer, whether you understand what I am saying, not whether or not you're recognizing the words. Do you understand what I am saying?
I overstand what you're saying.
I have to admit there was a brief moment where his remark was unexpectedly funny, and it caught me off guard. Even in the middle of the chaos, he managed to deliver a line that broke the tension for a second. That said, the humor does not cancel out the larger issue, which is the constant disruption of a formal legal proceeding. Court time is valuable, and every minute involves judges, attorneys, clerks, and staff whose work is structured and scheduled with precision. When someone treats the hearing like a stage for performance, it drains resources and slows down justice for everyone involved. The legal system is not designed for entertainment, and obstruction of justice is a serious matter with real consequences. Turning a courtroom into a personal showcase only increases the risk of penalties and stricter responses from the bench. Now let us return to the proceedings and see how this situation continues to unfold.
You want to be?
Your Honor,
You have a seat.
I'm not.
Have a seat.
Your Honor, I haven't had.
Have a seat. You can play games with me all day. I got all day. I got all day. Have a seat. The other one's in custody. I realize we are now at least caught up within an hour. I think those that want to go probably want me to take a break about now. So I'm going to take about a 5 to 10 minute break. I'll come back out and then I'll call the case. The court's going to stand in recess.
Good afternoon, Your Honor. Daniel Magoo, here in Dewey Juris.
All right. So on this matter, I was apprised of your rights. I told you about the charges in this case. We get to the point of understanding that there is a certain peril in representing.
Listening, sorry. My notes, I apologize, Your Honor. I meant no disrespect.
It truly felt intentional because casually walking away while the judge is speaking is not a small oversight that a courtroom demands attention and respect, and treating it like a personal space sends the wrong message immediately. Ignoring the bench during active proceedings is one of the fastest ways to invite a contempt warning. Judges rely on order to move cases forward, and visible disregard for that order can quickly lead to serious consequences. Moments like this raise questions about awareness and judgment under pressure. That in a legal setting, attitude matters just as much as argument, because demeanor often shapes how the court responds. That if this pattern continues, the outcome may become far more severe than it needed to be. Let us return to the hearing and watch closely to see how this approach impacts what happens next.
And that the court will treat you the same as an attorney in the case. You understand, sir? Listen closely to my question. Do you understand that?
I do not understand.
You do not understand it.
No.
The court, you will be presumed to know the rules of procedure as well as the Michigan rules of evidence, that the court will not be giving you assistance in regard to this case.
What I'm trying to say, Your Honor, is I do not understand the charges that are pitting against me, because they violate a lot of my rights. And the prosecutor served me the discovery packet on the 27th of last month. Since then, I have not received any kind of evidence or any kind of claims that I violated any kind of anything that day. So I'm here waiting for that to occur. So no, I don't understand.
Waiting for what to occur?
Well, under the rights to due process, Your Honor, 4th, 5th, 8th Amendment, there has to be substantiated amount of evidence to accuse me of a crime, like assault on a police officer, obstruction of justice, and resisting arrest. I take these charges very serious, Your Honor. Because of these charges, I have lost custody of my son, and I want to make sure that these justice is served and equity is ensured here.
Sir, I just asked you before whether or not you understood the charges.
And I answered you, Your Honor. I said I do not understand them.
Whether or not you disagree with them or not, is not the issue. The issue is do you understand what you are charged with?
I do not understand, Your Honor.
Is there a reason other than what you said that you do not understand?
I can elaborate a little further, Your Honor. I'm still waiting.
I wish you wouldn't. I just need to understand why you don't understand.
I'm trying to get there, Your Honor, if we could talk about it.
I'm not asking you whether or not you agree that you should be charged. I'm not asking whether or not you believe that you did it. I'm not asking any of that. I'm asking whether or not you understand what you are charged with.
Can we agree to disagree on a legally?
We are not going to agree to anything. This is not your game to play here. You play by my rules.
So you're saying that I have to say the words, I understand?
Sir, I'm not saying that you have to say anything.
Okay.
You know what? Here's the thing. I am not going to play this game with you.
I'm not.
So what? No, you are playing a game.
not.
So no, you are. And do not interrupt me ever again. Do not. So what I'm going to do is I'm going to give you a week to think about it, because I'm not going to sit here, call your case up 4 or 5 times for you to sit here and to go through this whole, try to play some semantical game. So I will adjourn this out to December 12th, 2024. I will adjourn it to 9 a.m. or I will. Do not interrupt me.
I can object to that.
Do not interrupt. Do not. One more time. You're going.
At this stage, his behavior has shifted from mildly amusing to openly disruptive, and it no longer feels harmless. What may have started as comic relief now looks like a pattern of delay that slows the entire proceeding for everyone involved. When hearings stretch longer than necessary, it affects not only the court but also the parties waiting for resolution. Time in a courtroom is structured, and every unnecessary interruption places additional strain on the schedule and public resources. Some observers may feel that stronger actions such as a contempt finding would restore order more quickly. Others may see Judge Simpson's patience as an effort to ensure fairness and avoid acting too hastily. Balancing discipline with restraint is one of the most difficult parts of managing a courtroom. The question now is whether continued warnings will correct the behavior or whether firmer consequences will become unavoidable as the hearing moves forward.
I've given you fair warning. I'm adjourning the proceeding out. If you are objecting to that, objections noted. It's still adjourned out to the 12th. Bond will continue. You
Your
may
Honor,
leave now.
I have constitutional.
You may
violation.
leave now.
Let's go.
I have a right to
You
a counsel.
may leave.
Do I not have a right to a counsel?
You want an attorney? You may get want an attorney, sir?
I need somebody to explain the problem here.
Do you wish to be represented by an attorney on this?
I do not need to represent myself. I'm presenting myself. I'm the only one that was there in this courtroom. No one was there. I don't recall anybody that was there that day. I'm the only one that knows what happened, Your Honor.
Do you wish
and I was
to be
violated.
represented by an attorney? I'm not going to sit here and argue with you. If you wish to be represented by an attorney.
Your Honor, I have constitutional violations.
Do
That
you
means
wish to be represented by an attorney,
you
sir?
take an oath to defend the Constitution of the United States of
Then,
America.
if you do not want to answer my question, Mr. Allen, he is to be removed from my courtroom.
When Judge Simpson calls out for Mr. Allen, you can feel the tone shift immediately because that usually signals a serious moment in the courtroom. It carries the same weight as a parent using your full name, and everyone understands that consequences may follow in this instance. However, the defendant avoided a contempt finding and did not receive jail time. Instead, he received a firm verbal reprimand and was allowed to leave without additional penalties, which many would consider a fortunate outcome. Given past examples where Judge Simpson has acted decisively for far less disruption, this result suggests a measure of restraint. Whether that restraint came from patience or desire to conclude the matter efficiently is open to interpretation. As for the broader issues mentioned regarding custody matters, those decisions are handled in separate family court proceedings. Family courts evaluate stability judgment and the best interests of the child based on evidence and established legal standards, not on isolated moments from a single hearing. If someone struggles to demonstrate responsibility in one legal setting, it can raise concerns, but custody outcomes involve many detailed factors. Ultimately, this hearing stands as another example of how courtroom behavior directly shapes judicial response. That concludes this review of the case, and it remains a memorable exchange worth revisiting. Share your thoughts on whether Judge Simpson struck the right balance between patience and discipline, and stay tuned for more coverage of notable courtroom proceedings.